Hey, good evening, everybody. Thank you for being here. This is Courtroom Insider. My name is Nate Eaton, coming to you live from Phoenix. Today is the last day of March 2025. 1 year ago today, we were in Idaho getting ready for Chad Daybell's trial. 2 years ago today, we were in Idaho, Boise, getting ready for Lori Vallow Daybell's trial, her first one. Now, here we are in Arizona. It's the first day of jury selection. I feel like it's been a week. I feel like I've been here a week. A lot happened today. There's so much to go through. We're going to try to fit it all in, or most of it at least that we can. Would love to hear where you're watching from in the comments below. And if you have any comments or questions, please put them below. Peggy, our moderator, is keeping track of that. I normally dress a little down for this to be more casual, but I'm wearing my tie tonight because justice prevailed, I believe, in not having me testify. And I wore this tie today that I'll tell you in a minute. I bought it this morning on the way to court because I realized I forgot one. But we'll get into that a little bit later. We have a lot to talk about tonight. As I said, jury selection and Lori Vallow Daybell is fired up. You could say we have the clips. She did not hold back today during court. I'll play some of those for you tonight as we get going. Here's what we're going to talk about. Jury selection beginning. It was actually pretty rapid, pretty quick this morning. Lori speaks her mind during the hearing this afternoon. And the witness debate over yours truly. Will I be a witness? Will I not? The good news is I won't, but I'll play you some of the footage, the video from the arguments this afternoon. And honestly, I will tell you, I was surprised to hear why Lori wanted me as a witness. And actually, I could see her line of thinking where it might make sense. And well, we'll get into that. And also she said that she did not file me as a witness to keep me out of the courtroom. She hadn't even thought of that. And I think I believe her. I don't know if she thought that far ahead, but we'll talk about that in a minute. We're also going to talk about the judge ruling on a bunch of other motions. All those motions we went through last week here on Courtroom Insider, which you can go back and watch. Last minute motions that Lori filed, the prosecution responded. A couple of motions that the prosecution filed. We'll go through those. I'll let you know how the judge ruled. We will remember Charles, and for some reason I'm missing a gap there. We'll have shout outs, cities, and your questions, and Rachel Smith. How could I forget that? I did that out of order. She is here. She has some fascinating things to say. She, of course, was the special prosecutor in Lori Vallow's first trial in Idaho. She also helped with the Chad Daybell case up until a few months before it actually went to trial. And she has some really fascinating things to say, including the observation that we should all pay attention to when it comes to male jurors, men on the jury, and some inside strategy that the prosecution in Idaho had Lori taken the stand. So we'll get into all that. I really think you're going to enjoy it. Hopefully. I hope that's why you're here. Okay, jury selection. Let me run through what happened this morning. I'm going to move myself down in that far corner. The judge, what happened was a bunch of people in Maricopa County, population 4.5 million. That's not just adults, that's everybody's got questionnaires through email. And they filled those out last week. And a lot of them were returned, or the majority of them were returned, I guess. And what the judge did is he said, okay, juror number 1526 noted that they have seen media coverage and they can't be fair. I recommend that they should be struck for cause. The prosecution would say, we agree. Lori Vallow Daybell would say, I agree, and then they would strike them. Then others that didn't get struck remained. And 52 passed today, which is not bad considering. So 52 made it through. This, by the way, this was all done in like 2 hours. This or an hour and a half. I mean, they really moved this morning. In-person voir dire will begin tomorrow. So what they're going to do is those 52 people will come in to the courthouse and they will be questioned one-on-one. They will file in the courtroom, and the judge has said that every seat in that courtroom is going to be needed. So there's a chance we may not get in. Now, there is a media room at the back that I'm going to try to sneak in. Not sneak in. I have the right to. It's a media room, so I can go in there. So that's what happened with jury selection. You are now up to date. Now, let's talk about the motions ruling. Several motions, as I mentioned. These were all filed recently. The judge hasn't had a chance to rule on them. Some of them, Lori Vallow Daybell filed from her jail cell. Others were the prosecution responding. One of the things, we'll run through these, Lori asked that a question on the juror questionnaire be changed, that it include a bolded and underlined phrase that Lori Vallow Daybell denies these allegations. Well, the judge said, I'm sorry, the questionnaire already ran out. Your request is denied. There was an issue about Daniel Coons, a retired police officer from the Gilbert Police Department. He's been listed as a witness for some time as a police officer, and apparently within the past few months or weeks, the prosecution has changed him over to an expert witness, a firearms expert witness. And Lori Vallow believes because he's testifying as an expert rather than a police officer, that should not be allowed. The judge tabled that one. He didn't necessarily rule. It sounds like when this officer is called, Lori Vallow will be able to cross-examine him and ask him some questions about that. So that motion was tabled. Then we had the motion that Lori filed to exclude 3 of the state's witnesses, and the judge denied that. One of those witnesses was Kay Woodcock. Lori is making accusations that these 3 conspired with each other to talk about things. In fact, let me just play a little clip of what happened during that portion of the hearing today.
I have next defendant's motion to exclude state witnesses dated March 14 of 2025, and the state's response, specifically defendants requesting to exclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. The state filed a response on why let me just make sure I'm looking at the right one. The state's going to offer some sort of testimony from these 3 witnesses that are going to talk about, it'd go toward the element of premeditation and or motive. So what is your objection specifically?
Mine, Your Honor?
Yes.
Oh, my objection was that after their interviews, after their defense interviews, that it came to light that their information came, well, one specifically came from Dateline, and then they called each other and their information came from each other. So
I guess I'm working a little bit in the dark. What information is that?
whatever they're, I don't know, planning on testifying about, none of them have personal knowledge of any kind of crime, so.
The state's not saying they have personal knowledge of a crime. They have personal knowledge of things that may lead a jury to infer some sort of premeditation or motive. So what information is that? Let me ask the state. Or what's your offer of proof on why they're relevant?
With regards to Christina Atwood, she is a person who was present when the defendant was speaking about the victim being possessed, which goes to, again, the motive of this as well as the premeditation, and those statements were made months in advance of the actual murder. With regards to Nancy,
So that's going to be offered as some form of admission from the defendant.
So that would be admission by party opponent, and that's personal knowledge.
Did you say that was Nancy Jo Hancock?
So that was Christina Atwood.
Christina Atwood.
Nancy Jo Hancock is the last person that saw the victim alive prior to that. What she knew about this was hearsay, but her statements to the victim of what he should do were her understanding and expression to the victim that he should tell the defendant that he had changed the life insurance policy to stop all of this from going on. So she both sees him the night before, is aware that he's there, and then she makes statements to him regarding what he should do.
Okay. And then,
Kay Woodcock is the person who actually obtained the life insurance policy, which the state is alleging is part of the motive. And she also has information relating to the victim himself. There are allegations, again, of the self-defense, the use of a baseball bat, so she can provide background on the victim in that area as well.
all right. Do you want to have further argument?
Just the fact that this information that is supposed to be coming forward is not, all these witnesses are getting together and talking about all this and comparing all their notes and all these things beforehand, and then they're telling us that in these interviews. Well, I talked to her 100 times. Well, I talked to her every day. Well, she told me this. Well, she told me that. So their information is not firsthand. These witnesses are all coming together. They're all watching everything that goes on TV regarding this, and I would like them all precluded.
Okay, well, you're always allowed to cross-examine a witness about any biases they may have about those things that you've just talked about, colluding with other witnesses. Those are all areas of ripe for cross-examination, but they're not bases to preclude a witness. The court finds that, based on the state's avowal, that those three specific witnesses do have some minimal, although very limited, relevant information to provide and could be helpful to the jury in understanding the case. So the court will deny the motion to exclude the state's witnesses. Again, this ruling doesn't preclude you from any objections you may have to, if they're testifying to hearsay or something like that.
Okay, so denied for Lori Vallow Daybell. Kay and the other two will be taking the witness stand. Now, the other motion, and I hope this is the last time we'll talk about this, was to have me struck from the witness list. And I learned this morning around 8 o'clock that there was going to be this 1:30 hearing and that I may need to speak, but our attorney said he could speak. For those just getting up to speed on this, a few weeks ago, Lori Vallow filed a list of witnesses that she wanted to testify on behalf of the state, on behalf of the defense. That's problematic because as a witness, you're not allowed to be in the courtroom to hear other witnesses. It would stop me from reporting the news and basically put a gag order on me. Plus, I have nothing to testify about, nothing to witness. I filed a motion last week. We hired counsel here in Arizona to file a motion. He specializes in media law. He's done a lot of high-profile work. He represents the local media here. He filed a motion, and he showed up today to argue on our behalf. I realized as I was leaving for the courthouse this morning, I'm like, I should probably be in a tie, and ideally, I would have a jacket, a suit jacket, which I didn't bring with me. I meant to bring a tie and forgot. I forgot about a belt. I mentioned that this morning, and a kind viewer out there sent me a promo code to get a free belt, so thank you. And it was like 9 o'clock, and like clothing stores aren't open at 9, Macy's or Ross opens at 9:30, I learned. Anyway, I ran into Walmart, and thank you, Walmart, for the $10 tie. I will keep this tie forever. It's my good luck tie because the judge ruled in my behalf. I'm going to play a little bit of the back and forth about why Lori wanted me as a witness, which was interesting to hear, and the judge's response. I will be honest, I thought for a second there he might grant her motion either in part or in full. And I was a little worried because my colleague, Nate Sunderland, had to take the stand in a trial last December, just a few months ago. It was a civil trial between two businessmen, and our reporters' phone calls were subpoenaed, and one of them was played in court. And our managing editor, Nate, had to go to this trial and testify. he also was not allowed to be in the courtroom at all except for that testimony. So I was a little worried, like, oh no, what if the judge does, throw her a bone and say, okay, Nate can testify, or Nate can be your witness. Anyway, here is how that played out this afternoon.
Is there a Mr. Eaton here appearing?
Your Honor, Matthew Kelly, I represent Mr. Eaton.
Okay. You filed a motion over the weekend. Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho, and based on the filings, believes he doesn't have any relevant information and shouldn't be listed as a witness. So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But there's several things off the top of my head that is relevant. Right now, one of the things is it's different now, right? Because he's had this off-the-record conversation with the prosecutor, and he's kind of made himself a witness. He's kind of made her a witness.
How so?
In the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back up. How is he a witness to this trial? How does he have relevant information? Relevant information means a witness has testimony that makes some fact in the case more or less likely. So how does he have relevant information for what this case is about?
Okay, so initially when I put him on my witness list, my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial, in calling him. I found it funny when I read the beginning of this. He says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
All right. Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
I've been watching most of the interviews and I take my own notes, so yes.
Go ahead.
Your Honor, two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness, the party calling him would have to comply with ARS 12-2214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements, but if, I would suggest that if she wants to call him as a witness, she would absolutely have to follow the requirements of the subpoena law, and we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
All right. I'm just thinking through this problem. If a witness got on the witness stand and said something different in testimony than you saw on an interview with Mr. Eaton, you would then play that interview. You wouldn't even need Mr. Eaton to do the impeachment, because you could impeach them with the interview by playing it for them in court or something like that. So now that I'm kind of thinking it through a little more, I'm not sure.
And I wouldn't need him to lay that foundation for the interview?
I'm really trying not to give you any legal advice because you are acting as your own attorney, but if the witness admits that's them on the interview and that's their statement, that is foundation. So
He's interviewed law enforcement, almost all the law enforcement that's going to be, up here on the stand. So it's not just witnesses, it's law enforcement.
well, when I say witness, I mean generally any witness, regardless of their occupation. So I don't foresee, I see it in only the narrowest of situations where he could even be called to as an extrinsic person to testify about the impeachment. You'd have to jump through a number of hoops before that as far as presenting the witness what the statement is, and depending on whether they admit or deny that it's them on that video or interview or whatever the case may be that you're referring to. But I'm inclined to strike him as a witness at this time, allow him to be present if he so chooses in the trial. But then again, if you wanted him as a witness, you would need to subpoena him. But at this point, I'm going to strike him from the witness list and permit him to be in the courtroom. If there's a situation where you think something has happened during the trial where you think he should be called as a witness, I guess we'll cross that bridge when and if it comes. Okay?
We could just call him up from the back?
Well, we'll address it when and if it comes, yeah.
And Your Honor, I would ask that if that were to occur, that I would be notified and given a chance to appear and be heard.
Well, everyone will get a chance to be heard if we cross that bridge. I just don't see us crossing that bridge, but I could be wrong. So at this time, it's sort of striking Nate Eaton from the witness list. He can be present if he so chooses in the courtroom.
Thank you, Your Honor.
The next one is legal advice to defense witness Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court. So how is that improper?
It's taking her word for that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only two parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there, and we don't know who's saying it, and you're just taking her word for it like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court, and I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Ms. K, okay? Just because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom. I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing. Even if she had said, you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation. Is that correct?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do we
All right.
know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can
interviews
interview him.
recorded?
You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness, okay?
not a witness anymore because you just precluded him?
All right. You can interview him. You can have your investigator interview him.
So
That's-
even though he's not a noticed witness now, we can still interview him and try to find this information because we can't get it now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Okay. I don't know if I should respond. I have not interviewed one person on the prosecution's witness list except Kay Woodcock. I don't know where Lori is saying that I've interviewed all these people. I just pulled up the list to double check. I have not interviewed one of those people. On her witness list, I have interviewed Summer and Adam Cox. Okay, I did interview Adam Cox. You're right. He is on the prosecution's list. That's it. Furthermore, there was two motions there. One, strike me from the list, which happened, and then two, she's alleging prosecutorial misconduct because she says Trina K gave me legal advice on or about March 11th. That's the day I went to Arizona. I did not speak with Miss K at all. The following week on the 18th, there was another hearing. Lori says that maybe Trina told me not to come because I might get served at that hearing with a subpoena. That's not true. I simply didn't go because I had other plans and had gone the week before and couldn't come back 2 weeks in a row. But on the 18th, after that hearing, I did email Miss Trina K and I said, Trina, I'd like to talk to you off the record about this subpoena issue and me being on the witness stand. Do you have a minute to talk? She called me a few hours later and we talked. She did an interview with me as she would with any other witness. She said, we will count this as our interview. What knowledge do you have of the case? And a couple of other things. I then said, I hope that the judge precludes the witness list or I might need to hire an attorney. And she specifically said, I can't give you legal advice. I cannot give you legal advice as the prosecutor. But if you're on that list, even if you don't get a subpoena, you can't come in the courtroom. That's when at East Idaho News, I worked with an attorney to prepare the notice that I filed. We hired legal counsel in Arizona. And I met and spoke with in person for the first time today, Trina K, in the hallway outside of the courtroom. That's it. So just to clear the record, that I was never given legal advice by the prosecutor. And also, I have never been contacted by Lori's defense team. I've told you before, I have spoken with Lori before all of this back and forth months ago. In fact, we were communicating daily. But I have not heard from her defense team. And I think they could find me if they needed me to. But also, I try not to give my opinion. Perhaps her defense team realizes that they should focus on other aspects of the case rather than trying to get me. Perhaps. Okay, that's it. That's all I want to talk about for that. So you can watch the whole hearing on our YouTube channel. But I mean, well, there's still more. Don't hang up yet. Don't turn off yet. There's still more, but I'm talking about me being as a witness. Some other motion rulings. So we talked about the juror question precluding me as a reporter, as a witness. I said as a reporter, I'm still a reporter, but I won't be a witness. The judge granted a motion by the prosecution to keep witness personal information private. For instance, if during the trial an email address is read out or a phone number or a social security number, we as the media need to block that and not get it out. Seems rational. Also, preclude Lonnie Dworkin. This is Lori Vallow's expert who knows everything there is to know about cell phone data and gathering information and everything like that. Lori Vallow said that he hasn't had a chance to work on the case, and we're in jury selection, and that he was going to send over some sort of motion tonight to say what he found, some irregularity or something. The judge said, sorry, he's off. We can't have him come in to try. He said, I already gave you a continuance to get that information in. I gave you more time. He didn't send it in. He's gone. So he will not be testifying. Lori's one and only expert will not be testifying. Precluding Lori's witnesses. This, by the way, when I say preclude, it means exclude. The legal system has to make things confusing, or I should say the English language has to make things confusing. The prosecution said that Lori filed her witness list way too late. And because of that, none of those witnesses should be allowed to testify. And not only that, the prosecution is having a heck of a time trying to reach these witnesses. Some of them, they can't to this day, and the defense admits they can't either. So if the prosecution deserves the right to interview any of the defense witnesses, much like the defense can talk to the other witnesses on their list. And here's a little bit of the back and forth over the witness issue. There was so much sound here I could have pulled, but let me just play some of it.
Everyone I've spoken with has not been.
All right.
Your Honor, our subpoenas are with OPDS right now, and they should be being issued currently. The state talks about in their response, like the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years since this case started? They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dworkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not gonna let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice to the other side with the limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dworkin late in the game that they did. I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power, with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say...
And I shouldn't be able to represent myself because of that fact? That negates my constitutional right?
I didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks, that makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother Alex Cox and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
So what I'm struggling with is you just saying that it's relevant doesn't actually make it relevant. It may be relevant. I'm trying to find out the relevancy. What you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right, Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper and I need to make sure witnesses have relevant information. And just like you have the right to interview all of the state's witnesses excluding victims' rights, people that can deny having an interview, they have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
They also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this other than maybe we should take it up as we progress through the case, but
Your Honor,
some of these people may or may not be even served.
Yeah, my concern is, obviously, I have attempted to reach these people. I've made my good faith effort. I've been told both by myself in attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point, then the state can try to, at that point, preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them, I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. Even if they submit to interviews, I may have to make a determination whether their testimony is relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest.
So I'm gonna stop there. There's so much more fiery stuff. You can go watch the whole thing on our YouTube channel when you have a minute. Remember, this is day one of jury selection. normally jury selection week is very slow. Like, what are we going to talk about? Yeah, this juror made it through. This is not the case. And if this is a foreshadowing of the trial, we're going to have to make Courtroom Insider 3 hours every night because there's so much to talk about. So let me go real quickly. The rest of the motions that have been denied. Lonnie Dworkin was granted to get rid of him, not have him preclude Lori's witnesses. The judge is going to take it on a case-by-case basis. The prosecutorial misconduct was denied. And one other one, Lori has felonies that she's been convicted of in other states. The question was, do you let the jurors know? The judge said this will only become an issue if Lori decides to testify. And if that happens, then the judge will decide at that point if Lori decides to testify, if all of her felonies should be revealed or just one or two. Because it can obviously, if a juror hears, holy smoke, she's been convicted of murder, her children, and her another woman, Tammy Daybell, that's an issue. It could change a juror's mind. That's everything that happened today in a 30-minute window. Let's get to Rachel Smith. This is a interview that I think you're really going to like. She gives us some insight into what to watch for at the trial. Remember, Rachel Smith has done over 100 or so homicide cases. She was a special prosecutor in Idaho in the Lori Vallow and Chad Daybell cases. She's done death penalty cases. She knows her stuff. And here is that interview. Let's take it away. All right. So Rachel Smith joining me now. Rachel, what questions do you hope are answered in this trial? Do you have any?
I think everybody's got a lot of questions that we would like to have answered in this trial. I really think for me, I would love to see more information about exactly the planning that Lori and Alex did throughout, but especially targeting Charles, which is very different and wasn't the evidence offered in the Idaho cases. So I think we'll see some more evidence, more about Alex. In the Vallow case and even in the Daybell case in Idaho, there was discussion of Alex, but not a lot. I think this time we'll see much more about that relationship, that conversation between Lori and Alex, because that's part and parcel of Lori's conspiracy to kill Charles.
In Idaho, were you all somewhat limited on what you could bring in as far as the Arizona connection, or was it free reign?
We were limited, but we got in what we needed. And it's something called 404B, evidence of other crimes for some states. Same thing. You're only allowed to bring in evidence of unconvicted conduct or even convicted conduct if you can show the court that information is directly related to your case and the value to the jury is greater than the harm it can do. So we were limited. We got in what we needed to get in. We had the early hearing. The judge made the rulings. So a lot of the Arizona evidence that Trina Kay and the Maricopa County prosecutors have probably won't have been heard before, at least in court.
Interesting. And I mean, the 404B, you mentioned that during Lori Vallow's Idaho trial, Jim Archibald repeatedly objected to that because they obviously didn't want that brought in.
Yeah, there had been a motion filed in Lori Vallow's Idaho case and in Chad Daybell's case to admit the 404B. And that was one of those many hearings that were held outside the presence of the public and the jury, to people's frustration, I think. But the 404B hearings typically happen outside the presence of other people, because if the court says it doesn't come in, then he hasn't now publicized it. So there was a hearing ahead of time. It was probably a good day, maybe 3/4 of a day, going over the evidence that we would be allowed in from Arizona into the Daybell case and into the Vallow case. So some of the evidence we wanted in wasn't allowed in, not a lot, but in this case, you're going to hear some of the evidence we wanted in that the court said was just not necessary in Idaho.
Oh, interesting. Yeah, that's the type of hearing I would have loved to be in
Yeah,
for
yeah,
all that.
yeah.
Okay, I want to talk about the prosecution's job in this particular case because Lori Vallow Daybell is representing herself.
Yeah.
How does that change the game for a prosecutor?
Pro se cases are a prosecutor's worst nightmare. And I think that's counterintuitive sometimes to the public, but as a
You think it'd be a
prosecutor,
walk in the park because they don't know what
yeah,
they're doing.
yeah, you think it is, but in reality, the appellate courts view it much more strictly. You want to make sure the jury doesn't think you're beating up on somebody. There's a natural sympathy, at least initially. I think Lori will wear that out pretty quickly with this jury, but there is a natural sympathy that goes on in a courtroom in front of a judge where the person's pro se. So the prosecutor has to walk that fine line between being a zealous and tough advocate and always appearing fair and always making sure that they are showing how balanced and even-handed. It's a little different handling objections when you've got opposing counsel. When you've got a pro se person who doesn't know how to do it, you have to be real careful on how you handle it. And trials always take longer. So in this case, you got an extremely experienced, highly competent prosecutor, a very experienced judge. And I think you're going to see a lot of patience and a lot of deference being shown Lori Vallow. And that's to protect the record because the goal is to convict her and convict her once.
Fascinating. So you're saying that when the prosecutor has to decide whether to object or not on certain things that Lori Daybell might question or oppose. I mean, how do you weigh that when in the back of your mind you clearly know she's going against the rules? Is it pick your battles, just kind of let it go, a mix of both?
Yeah, when a pro se defendant objects, I always just sit back and say, okay, is this really hurting me? Which is hard to suppress because most prosecutors are rule followers. And when it violates the rules, it bothers you. It's kind of like a situation where you just know it's wrong, but you have to let more go than you would normally let go. And you only do it if you think it's hurting you or if it's so egregious it could cause a reversal.
Have you ever seen a pro se defendant win?
I have not. I have not. What I have seen is courts of appeals scrutinize the trial judges very closely.
Mm.
This judge is a very experienced judge. The Maricopa team knows what they're doing. I think it may be frustrating to observers and listeners because it's going to feel like Lori's getting away with stuff. But it's really just people dotting their I's, crossing their T's, and making sure that there's no reason to send this back.
So for those of us watching, those viewers over the next few weeks that are like, why doesn't the judge get her in line? Why does he allow that? You're saying he really wants to protect himself and be careful as well.
Yeah, the court will work hard to protect the record, protect any outcome on the case, and that means they're going to show Lori a lot of patience.
Lori Vallow listed me on her witness list, and a lot of people have asked me the question, so can any defendant list anyone on their witness list just to simply keep them from attending their trials?
And they can, and defense attorneys do that as well. Oftentimes, that's a tactic used to try to keep certain people out of the courtroom. In some states, they'll even put victims or their families on the list to try to make sure that they aren't in the courtroom. What recourse the witness or the other side has is to file a motion with the court and ask for either a public hearing or an in-camera conversation. Like Lori can go back into chambers with the judge and say, this specific thing I intend to try to elicit. And if they can satisfy the judge, then the witness is out of luck. If they can't satisfy the judge, then the person is allowed in the courtroom.
When you say in camera, I want to be sure our audience understands because we've heard that term and people assume it means with a camera in the courtroom, but it doesn't really have anything to do with a camera.
No, it's that old English or Latin term, it meaning focused in private with the judge. So the the person or their attorney will go into chambers, the judge will question them, or they'll make a statement, sometimes called an offer of proof. It's on the record, but the other side isn't in the room. And this way they don't have to reveal a trial strategy, but they do have to justify their actions to the court. So it wouldn't be atypical for a judge to require the person to come in.
Okay, so the people on the witness list, really, it's up to the defendant to say this is why I may need them if the people on the witness list want to attend the trial or watch the trial. But I would imagine most of them just say, I'm not going to bother.
A lot of them say, or they don't have the means to fight it. Some witnesses just can't. Others are like, well, I didn't want to be there anyway. So sometimes they just throw in the towel and move and try to make sure that they can be available to testify and then come in later.
Have you ever seen a defendant list a journalist on their list?
Yes, actually, there was a journalist in Missouri who interviewed a defendant before a trial. He gave statements to the journalist, and then the journalist, of course, published some of that stuff and then withheld some of the statements, saying he would publish it after the trial by agreement with the defense. Well, the court allowed the prosecutor to subpoena the journalist, and the journalist had to turn over their notes, and the Supreme Court upheld it. So I have seen that happen, and it's usually when the belief is that a journalist has some sort of inside scoop.
Interesting. So if you were on this prosecution team, and I know that's a big if to say because you don't know all the ins and outs and everything, but would there be a theme that you would come up with or some sort of message that you would constantly try to get in the minds of the jurors?
Yes, I would really focus the case on Charles and who was lost, that Lori's desire for money and glamour, such as it was through her new boyfriend, Chad, the author, cost Charles Vallow his life. And so the case rightfully will be focused on evidence in Arizona. In this case, I'd keep it narrow and keep it focused on Charles.
How much stuff from Idaho do you think will be brought in about the deaths of JJ and Tylee? The judge has already said he's going to put their names on the jury questionnaire. But will we hear a lot about the children's death and the horrible manner in which they were found, or is a lot of that going to be limited?
I think looking at the witness list that the prosecution put forward, you don't see a lot of you don't see the people from Idaho. You don't see the people on the list that would be the way to introduce that evidence. So I think we're going to have a very limited trial. There will clearly be some mention of it. There will clearly be some conversation about the scope of the conspiracy. But it is possible the judge will limit the vast majority of it because Charles' death occurred first, and the argument may be the evidence of the children is and Tammy is too prejudicial and not as probative as necessary. I suspect we'll see a very narrow trial given this witness list that was filed by the state.
What did you think of Lori's interview on Dateline?
Oh, Lori is that interview on Dateline was what I was secretly hoping would happen if she testified in her own defense in front of in Idaho.
Idaho.
Yeah, we had talked about having Rob Wood do the cross because that's, at least looking at all the videos, paying attention to the witness statements, seeing how she interacted with law enforcement consistently. That is what she did. She tried to flirt or charm or maneuver her way around the situation, and we were secretly hoping that's what would have happened in her trial in Boise.
And that's why you thought Rob can do it, to see if she kind of goes back and forth with him versus a woman?
Yeah. Yeah. And there was also Rob just being of the same faith. There was some evidence based on her jail calls that she saw a special connection with Rob, which kind of you saw come out in some of the early motions filed by Mark Means. So Lori's connection and interaction with men is starkly different than her interaction with women. So that Dateline interview was what we were secretly hoping would try to happen in Boise had she testified.
And she specifically requested Keith Morrison. She
Yeah.
wanted on the #1 crime program, and she wanted him. Was any of her behavior surprising to you at all?
No, no. It really wasn't. What was surprising was how patient Keith Morrison was, because that would be extremely hard, knowing he followed it the entire time, like you, even before the children were even known to be dead. I can't imagine having to show that level of patience, but he did, and that behavior is what we really thought we would see out of Lori.
Hmm.
Had she testified.
And do you think we'll see that behavior all throughout the next month and a half, if that's how long the trial goes?
Yeah, we do, because there were times during jury selection we could tell there were certain men she really wanted on that jury. And so it was just the way she behaved. I think you will see some of that. What will be interesting, and hopefully you'll be able to be in there and watch, and so you can tell us. She will, to see if she'll try to look at the guys and make eye contact and make connection. I don't think she'll be obviously flirty right away, but I will be fascinated to hear from you whether she follows through with that sort of pattern of behavior.
Yeah, I'll have to, pay close attention because we'll obviously be hearing from her, I would imagine, versus, in jury selection in Idaho, it was mainly her attorneys we heard from. In fact, one of the jurors I spoke with after the fact who made it on the jury said she walked in the courtroom and thought Lori was one of the attorneys. She was dressed nice. She was there consulting back and forth with Jim and John. And then she realized on the first day of the trial, no, that's the defendant herself.
Wow.
So,
Wow. Yeah.
now that, you've been it's been 2 years, believe it or not, since that April 2023 trial with Lori. Has anything in your mind changed or stuck out to you as far as, what you experienced that whole time?
Oh, for me personally or
Yeah.
for
Yeah, you
cases?
personally, or the case.
Um, I've tried a lot of cases. I've handled a lot of homicides. This one has stuck with me in a way, and putting aside the media, because I haven't really been part of all of that. I've done a couple interviews with you and I answered questions for a couple people, but I haven't really lived with it probably the way Rob and Lindsay and Spencer and Tanya have locally. But for me, there will be times I will think about the case, or I received one of the wristbands, the remembrance bands from Kay and Larry, and I'll see that it's in my car, and I'll see that, and I think of them, and it sticks with me in a way that other cases haven't. The depravity of what a mom can do to her kids just really resonates. I'm not sure when that will go away. My daughter was about the same age as Tylee, so I can remember during going over and doing Dr. Christensen's testimony, and in the middle of it, I for whatever reason, I thought of my daughter. So that when you're a mom, when your kids are about the same age, that stuff just sticks with you.
Right. Do you have anything you wish you would have presented at the trial, or anything you wish you could have gotten in?
I would have liked to have gotten in more about Charles. I would have loved to have gotten in, but the judge absolutely made the right call. Would have loved to have gotten in some of her footage where she wasn't, where she was manipulating the police during the request for a psych eval. But, in the end, it was Judge Boyce did a phenomenal job. It's one less issue that could, although she's waived appeals, that could have been raised on appeal. So the judge made the right call, but I would have loved to see that. I'll be hoping to see that in this trial. I think there's every reason for it to come in, and I would be very interested to see the jury's reaction to it.
I know a lot of us in the public say, "Oh, we wish we would have heard more of those jailhouse calls between her and Chad," or things like that. Which I don't know how many of those. It appears the relevant ones were used, but and you probably could have played those all day, every day, but to no point.
Right. Right. Well, and you had to be careful in both trials because this was really a team effort by Chad and Lori. They really, to me, they mutually manipulated each other and mutually manipulated others. So playing too many of those phone calls, while interesting, you risk the idea that they would see some sort of power dynamic by Chad against Lori or Lori against Chad. Candidly, I was surprised that the defense didn't use some of them.
Oh,
So I was surprised that the defense didn't use more of some of those calls between Chad and Lori to make it look like Lori just, was manipulated by Chad.
all right. My thanks to Rachel Smith. If you missed any of that interview, apparently it cut out again. The computer I use, I have a couple of computers here, decided to do an update tonight, and so it's shutting down programs. I apologize. The Wi-Fi, I believe, is fine, but we're going to look into this. I apologize if you missed any of Rachel's interview. I will post the whole thing. Fascinating interview, and I'm going to pay attention to how Lori Vallow is responding during jury selection tomorrow when men get called up. This is the reason why we are here. Charles Vallow, shot and killed in July of 2019, father of JJ, whom he loves so much. He also took care of Colby and Tylee. He was an uncle. He was a businessman. He did a lot for so many. And so we remember Charles tonight, along with the other victims who have perished in these cases. And we think about them. I do want to pause here and give a thanks to our sponsor, Browning Law, Allen Browning Law Firm in Idaho Falls. They are sponsoring Courtroom Insider. They make it possible so we can come to you every night. I want to ask you to subscribe to our YouTube channel if you can. There we go. You can find me on Facebook. I'm on Twitter, X. I was live tweeting today. I'll be doing that again tomorrow. There won't be any cameras tomorrow. So if you go to eastidahonews.com, follow us throughout the day, or at X starting around 10:30 Arizona time. I'm also on Insta and YouTube, of course, at East Idaho News. I want to give a big thanks to many of you who sent in donations today to our newsroom. We really appreciate that, and I can't thank you enough. I was going to wear this shirt tonight, guilty of following eastidahonews.com. I might wear it tomorrow night. Just want it to be a little bit more appropriate today. Many of you ordered shirts, either that shirt or the Ain't Nobody Got Crime for That, or our I Come for the News, Stay for the Comments shirt. Big thanks to those of you that did that. And I promised my daughter, she gave me a bunch of Easter eggs to open one a day from now until Easter. And I promised her I would open this one on camera tonight. And she said I could read the note to you. Hi, Daddy, I'm so sad you'll miss your birthday here. Also, if you want, you can show this on Courtroom Insider. I love you. Love your favorite daughter, Emmy Swimmy. Thank you, Emmy. So nice hearing from you. And kudos to my wife, who is holding down the fort at home. It was the first day back to school today after spring break. And you know how that is. Many of you went through it today, just the madness of it all. And I miss taking my kids to school. But I think I got all those in. Peggy, let's get to your questions. So many of you have questions. First of all, the shout outs. Michael Jepson, my good buddy in Fruitland, Idaho. He's a physical therapist. He just moved there. Wish he was here to work on my shoulder. But if you need help, go see Michael Jepson. Wayne Cleverly, Tammy Camphouse, thank you for watching. Pat Kane, Tanya Ann, Geraldine O'Gorman, Rose, Kruger, Jana Grace, and Laura Welsh. Thank you for watching. We have people watching from all over. If you haven't put in your city or state, please do. Burley, Idaho, Macedonia. Where's Macedonia? Wow, that's amazing. Aruba, Meridian, Connecticut. Almost took a job in Connecticut once. Ireland, Holland, Denmark, Pingree, Idaho, back home. Round Rock, Idaho, Rexburg, of course, Spain, the UK, Australia, England, and Minnesota. A lot of good places. Now to your questions. I'm worried that if you're using a third-party company to order shirts, we will not be able to get them signed by Nate and the team. Help. That is true. We are using a third party just to make it easier. However, we are going to get shirts that we will put on our website that you can order directly through East Idaho News, and they will be shipped from us after the trial's over, and then we can sign them. So if you want to wait to get it, you can. If you want to order one today through our third party store, you can get it early enough. And then if we meet one day, I'll sign it for you. Laura says, I heard Charles's home sold. Where did his kids go? His sons are grown and have gone to college. Of course, Colby is out on his own. I believe that Charles was leasing that house, but somebody definitely new lives in the home. I went by the other day, and yeah, somebody lives there. Love you guys and all you do. Is there any way you can start Courtroom Insider a bit early, maybe at 7? The current time is 8. 11 o'clock on the East Coast is tough for so many. Well, it is 7, 8, 9. It should be 10 o'clock on the East Coast. So it's 7 o'clock Pacific, Arizona, 8, 9, 10. I realize it's late. Maybe we can bump it back an hour starting next week. The issue is that court's going to get out around 4:30, and then I've got to have time to get back here, and it takes about an hour or 2 hours to prepare. So the time was going to be tight. But thank you. Also know if you can't watch live, you can watch it the next day. It's always available on demand. Deborah, why don't they get the audio of Alex saying he could kill someone and make it look like an accident? Maybe they have it. I'm trying to remember where that audio is from, Deborah, but I would imagine if it's relevant, they can get it in. Jody asks if Zulema will be here. No, she's not on the witness list, and I will be stunned if she comes to watch. Stunned, but I hope she does. Zulema, if you're watching, I'd love to talk to you. Lori says, Lori, what do you think will happen to the cops who treated Lori and Alex with such kid gloves? I don't know. Some of them will testify, and some of them will, talk about what happened that day. There's been some of the officers who have retired. Some of the officers have probably left the department, but some of these officers we have heard from before. So we will see. We will see what questions Lori has for them. Have there been any procedural changes in the police department since Charles's death? Cindy just asked. Yes, there was a bunch of movement. I don't know all the specifics, but there was a bunch of movement in the beginning of the trial. And remember, this was almost 6 years ago. So a lot of the older guys that were nearing retirement have retired, have left the force. So they could, be out doing, they could be retired. Were any family members in court today? Nope, there weren't, Tara. And Tara, normally we'll start probably seeing family members next week when the trial actually starts. Jury selection, it's not very exciting. I mean, it's kind of, I don't want to say ho-hum, but kind of standard. Tomorrow, we're going to talk about the courtroom that this is in and the fact that Jodi Arias was tried on the same floor across the hall. Is Lori up for the death penalty? She is not. In Arizona, this is a conspiracy case. It's not first-degree murder, so she does not qualify for death. Heather says, if the trial is going to be recorded and start 30 minutes later after it originally starts, will we be seeing the beginning or will we miss the first 30 minutes? Good question. I'm a little confused. The trial will start at 10:30. We will start recording video immediately when it starts. At 11, this is all Arizona time, we will push play and you will watch from the beginning. You will see the whole thing unless a juror is accidentally shown or something is shown that shouldn't be, then we'll have to cut that out. But yes, you will see the whole thing. So we will get out of court 30 minutes before you finish watching it, if that makes sense. So yeah, you won't miss anything. If you stay tuned, you'll just be seeing it late. Thank you for conveniently adding the frequently asked question for the trial. Deborah says, for someone such as I who has the knowledge of the case, I become annoyed to sit through continued backstory on the case. I understand why Nate does it, but having the link is really appreciated. Thank you, Deborah. If you are looking for that, actually, let me show you here for those of you watching. Like if you're new here or don't know what we're talking about, this is if you go to eastidahonews.com, right here on the upper right-hand corner, Lori Vallow Daybell on trial, complete coverage. Click that, and here we have right at the top a digest, which is a daily newsletter. Somebody's calling me. We have a Courtroom Insider button, which is all the videos from our history of Courtroom Insider. Frequently asked questions right here. Here's a timeline. Here's a who's who, and here's videos. And then here's all of our stories we've ever done on the case. So you can find that on eastidahonews.com or our free app. Okay. While in Arizona, can you please look up the system as far as makeup and hair products go for Lori? okay, it seems ridiculous she can wear all that as a prisoner, but is it also because she's her own lawyer? Well, we know the clothing, the judge allowed that. From what I understand, you can get some basic makeup, and I don't know about hair from commissary. You can get makeup though. Lori was a hairdresser, and you can take the garments that they give you, like the shirts or whatever, wet them and twist them into, like, I don't want to call them tubes or whatever, and put them in your hair. As you can tell, I'm so experienced with my hair. That's how I understand. But I'll try to find some more information because that's interesting. I'm surprised Lori isn't being charged. This is Pat. After listening to your show last night, I'm surprised she isn't being charged with insurance fraud, since it seems she had Charles's account changed to password protected. Since she was not the owner of the policy, I would think it was a crime. Wondering what your thoughts are. Well, I don't know if we ever learned that she officially did change the password on that account. Ultimately, she didn't get any money. So I think if she had gotten the money, it would have been different, but she didn't get any money. And she was charged in Idaho for, well, Chad was charged with insurance fraud. She was charged with grand theft for taking the money of her children and Tammy. When a juror is dismissed in Lori's trial, do they leave immediately, or does the judge ask them to stay till they get through the group? Nope, they leave immediately. At least in Idaho, you're dismissed, you go. They get you out of there. You don't have to stay. Annabelle remembers how we find live coverage from the courtroom because I was lost today and couldn't find you. It's a little complicated, Annabelle, at least it has been so far. Starting next week, when Court TV is here, they're the pool camera, meaning all the media we plug into their gear. So you should be able to find us every day starting at 11:30 Mountain Time on the East Idaho News YouTube channel. Just go there, subscribe, hit the little bell. You'll get a notice whenever we go live. We were late today because Fox was the shooter, the camera people, and we couldn't get their feed. Behind the scenes stuff. Not anything bad on them. I'm just saying we had to wait to get the feed till it was over. Why didn't Lori call Chad as a witness? Could she have? I think she could have. That would have been fascinating. I don't know if the judge would have allowed it, but imagine her cross-examining him. Nate, maybe you can't answer this, but do you get the feeling Lori's calling you as a witness as an act of vengeance since you pushed her hard in Hawaii to get the answer to where her kids were? I really don't think so. And I say that because I've talked with Lori a decent amount of times over the past 2 years, and she's been very friendly, very polite, sharing recipes. I mean, really, I don't think she was upset with me. Maybe she is now, but I don't know. Kelly says, did you say you've been visiting with Lori in prison? No, she wanted me to visit her in prison, and I made the request. She wanted a face-to-face visit with me, and I tried in Idaho. Here they don't allow face-to-face visits, but we have communicated. I'm super confused about Charles's phone. What did she take? When did she get to take it on all those errands? After he was shot, she grabbed his phone and took off. Allegedly, she had the phone with her. She didn't leave it at the house. So he was shot and she grabbed the phone and left, most likely. Or she took the phone because they were arguing, left the house, and then Alex shot her. But regardless, she took his phone. Can the judge now determine that Lori is not equipped to be her own attorney? No, he can't. What is, I wanted to keep yelling, keep Nate's name out of your mouth. How do you feel? How did I feel? I'll tell you, it was surreal. It was so weird to be sitting there and hear her say stuff that I know wasn't true and just listen. And then, I wanted to kind of stand up and say, I probably could have. I asked my attorney, I said, you can do the talking. Do you want me to come up? He said, I'll take care of it unless you want to. And I wondered if the judge would call me up to say, Mr. Eaton, do you have knowledge of such and such? But he didn't. But it was a little odd, I will say. I mean, it was weird to be there.